Yes, thank you. Will, thank you. We're now going to get into, in many ways, a key area of medical jurisprudence and medical ethics about which each of us is concerned, and that's the concept of malpractice. Elements of malpractice. And we're going to talk about malpractice based upon negligence and malpractice based upon non-negligence theories. It is important to keep in mind anybody can sue anybody for anything. The next question comes in, can they prevail? And then, as important, can they collect? So what is this all about? The key is, when it comes to issues of malpractice, we're talking about the wallet. And that is one of the reasons we're going to talk about malpractice insurance during this course. And when we're talking about the concept of malpractice, and we're talking about the wallet, we're talking about protecting ourselves as physicians. We're talking about protecting patients, because what we don't want to have happen is we don't want our practices to go up in flames. So, this is the area now to which we are going to focus. We want to be certain that patients are protected. We also want to be certain that our practices are protected so that we can continue to provide the best care possible for our patients, to provide them with the richest lives that they can have and the most productive lives. Elements of malpractice. The key thing are the 4 Ds. And what are the 4 Ds? The 4 Ds are duty, dereliction of duty, direct causation, and damages. We're going to look at all of these and put these into perspective, flesh them out, and give them good details so we'll understand what those are. And again, when we talk about duty to patients as physicians, one of the key elements is to recall and remember every time. First and foremost, above the duty attaching, have we established a patient-physician relationship? If we haven't established a patient-physician relationship and we're not treating an individual, then we don't have a duty to that individual other than the human duty of being civil and polite. The duty hasn't yet arisen. Once we create a patient-physician relationship, then we have to be concerned about the concept of duty, to which we will turn now. Duty. First issue is duty. Does someone owe a duty? Who owes a duty to whom? And in this instance, we're talking about the legal issues surrounding the provision of professional medical care provided by the physician to the patient. Thus, as the physician, you owe the duty to the patient. What is the duty that is owed? In the law, the duty that is owed is called the duty of due care. What does that mean, due care? That means that we are obligated to perform our responsibility as a physician with the diligence of that due care. Meaning we are expected to exercise the degree of skill ordinarily used under similar circumstances by a similar professional. So we are held to a standard of due care to perform the skill that other trained professionals will perform. Key to that is, it is important not to practice outside your scope of expertise. Now, what does that mean? It's okay, we can, thanks.